As we heard earlier today from the Ministry of Trade and Fishery in Norway, the Norwegian government have worked on and launched a strategy and roadmap on how to increase women working both within the maritime but also the marine industry. It's a work where the industry and industry leaders have been asked to come with advice and input, and it's a work that has continued for more than 1 year. As a result to this, there is a roadmap with 4 clear advices. And while she stated that they will continue to work on this, the question I ponder and wonder about is whether or not a strategy and roadmap and a declaration of cooperation from our government is sufficient and enough, or if in fact we need harder requirements to get the change that we need. So to discuss this further, I'm very glad to welcome on stage where we will discuss the topic surrounding this, and that's diversity and inclusion policies, exploring the legal framework and best practices. To moderate this session, I invite Mrs. Priya S. on the stage, and she will also be joined by Katarina Smith, which is the Senior Legal Counsel at Oldendorff Carrier, Magdalena Chu, and she is the Director at AsiaLegal LLC. You're okay? Yes, good. Wonderful. And then I would be welcoming up Jacqueline Zalapa. She said that, did I say it wrong? Okay. She's partner at Campbell, Johnston and Clark. I welcome up Rania Tadros. She's the office manager partner at Stephenson, Harwood, Middle East. And Amsha Gengan. She's advocate of the High Court of South Africa. So welcome.
Good afternoon, everyone. I hope you'll have been having a good time so far. We've got 6 lawyers on stage. And Sanjam comes and tells me, don't look at the timing, you just got half the time. So just wrap it up as speedily as you can. So, getting on with it. Let me just quickly. So our topic for today is diversity and inclusion policies in the maritime industry, and also to explore what are the legal frameworks in place and the best practices that we think are good for promoting diversity and inclusion in the maritime workplace. So before we go further, a very brief introduction of the panel that's here today to speak on this. We've got Catherine, who is one of the senior legal counsel at Oldendorff Carriers based in Singapore. Prior to moving to Singapore, Catherine was based in Hong Kong for 15 years as a maritime lawyer with Holman, Fenwick & Willen, and then as a general counsel and company secretary for a Hong Kong shipowner, Wah Kwang Maritime Transport Holdings. I hope I got the spelling right. Catherine is a past president of Vista Hong Kong, and she's a solicitor, a lawyer, as well as a fellow of the Chartered Institute of Arbitrators. We then have Magdalene, who has set up her own firm, AsiaLegal, with 3 others in Singapore in November 2002, which then, she entered into an alliance with HFW AsiaLegal in July of 2015. She is appointed to the expert panel of the Singapore Mediation Center. She is a senior accredited specialist in the maritime and shipping law by the Singapore Academy of Law, past president of Singapore Vista, and a fellow of the Singapore Institute of Arbitration. We have Jacqueline, who's a partner in the London office of Campbell, Johnston and Clark. She's a tri-qualified lawyer. 6 were not enough. She comes with 3 of them in 3 international jurisdictions, that's England and Wales, United States and Australia, and has practiced in each of these jurisdictions in the last 20 plus years. She has a particular interest in the Indian market and has co-authored the inaugural maritime law textbook published by India's Center for Maritime Law. It's Through the Lens of Maritime Law, a Worldview. We have Rania, who's the managing partner of the Dubai office of Stephenson Harwood, a renowned shipping and oil gas lawyer. She's also the president of Vista UAE. She's got over 20 years experience in servicing clients in this area, widely regarded as one of the leading lawyers in the market, which is reflected through the various accolades she's received over the years, including the DIFC Lawyer of the Year Award. And lastly but not the least, we have Amsha, who's a practicing advocate in South Africa. She was called to the bar in '99, and she's here today as a strong supporter of the Maritime SheEO. She's a passionate advocate for women in shipping, and she is the current president of Vista South Africa. So that's the absolutely erudite panel that we have today to discuss diversity and inclusion policies in our industry. Sometimes we often wonder, isn't inclusion actually just an integral part of the society? Why is there a need to define it at times? Why is there a need to specify it, to promote it, to actually perpetuate it down to the last letter? But in reality, inclusion is not always included, and diversity is not often recognized enough. There is a need to keep pushing boundaries. There is a need to ask questions from time to time. There is a need to raise awareness on the subject so as to perpetrate this thought into every aspect of our society. And that's what we are here today to do, to try and bring about some more awareness in the topic. We will first start with Rania, who will speak about the requirement for diversity and inclusion policies and whether there is a requirement to promote it in the workplace when it is really essential and it's so obvious to us. Is there a need to be put down in the form of a written policy?
Thank you. This is a question that actually I always find really difficult because we are stating the obvious. If you ask someone, is diversity important? I don't think anyone would say, no, it's not important. We can't be sorry, is it working? Yeah. We can't be gender blind, but the reality is that whatever we've been doing for the past, since humanity began, is not good enough. I attended a conference in Dubai a month ago, and there was a presentation by a big airline about how they started their policies, if you like, for diversity change 60 years ago. And then they report on current progress, and it's still under 10% in leadership. So they are very proud of the fact that they started these policy changes 60 years ago. But all I could see was 60 years has not done anything. It has not done enough. So clearly we need to do something different. And you can draw parallels, and I think this was done in the previous session, with carbon emission goals, for example. You know, the impact on the environment of shipping, of carbon emissions from a variety of different forms of transport has always been there, but it's been accelerated because we're now afraid. I'm not saying people should have women on their boards and in their leadership because they're afraid, but I do believe that we have to do something differently, in the same way as they're doing something differently with respect to controlling carbon emissions and protecting the environment. I think we do need to spell it out. Is it important to us as a company? Is it important to us as a community? Is it important to us as a society, as a government? And then just simply look at the bits which we can control. I'm not a lobbyist, so I don't believe I am able to control the policies of government from where I sit. All I can do is promote the policies that my own company has. And so I start with that. I start with developing policies within my own company, realistic targets. And then I look to my clients, and then I look to my clients' clients, and then I look to my clients' service providers. And that's the only way I think we can start to impact and have a degree of change. But it all starts from the recognition that we have to do something different. We have to stop talking about it, and we have to do something different.
Well, that's very true. We do have to start doing, but sometimes I believe that in addition to doing, we also got to start talking about it. Unless and until you raise the topic in different forums, you are not going to be able to get a variety or a spectrum of how the other part of the society or the world is really dealing with this. And to that extent, I think it's important that we start raising awareness in whichever form and manner that we think is most appropriate in the set of circumstances that is before us.
You're absolutely right. I was very lucky. I started my journey as a lawyer in a shipping law firm in London in 1998. My first seat was with a female partner.
Right.
She was the only female partner in the firm. But it made me not think that there were barriers, and it also made me realize that I had a role model, whether I thought about it or didn't think about it. I sat with her on a panel for International Women's Day about 2 years ago, and she said something that really triggered me to think slightly differently about this talking. She said it's not only women who don't have role model, it's men who don't have role model. So like in the previous panel, the gentleman who was trying to save the woman from a business trip post her giving birth because he didn't want her to leave her children. It's an admirable thought,
yes.
But he didn't have a role model of someone who had made the decision for themselves.
Right.
So you're right, we do need to talk to provide role models for the whole of society.
Yes, absolutely. I fully understand where you come from. When I joined the legal profession, and I have Monica for company who would also confirm that, we were in a firm or in a chambers that's full of male lawyers. And when I joined, I was the only female in the office. So you do understand what unconscious bias is, which was spoken of in the last session, and the need to actually make the society or your environment aware of this, of the need for change. Sometimes things go by and people don't realize that there's a requirement for change. I will now call upon Amsha to address us on why she thinks legal frameworks and policies are essential, and also to speak a bit about how it's being given effect to in South Africa.
Thank you, Priya, and good afternoon, everybody. So I think in answering that question, let me begin with the end in mind. And the end, or the solution, or the answer to the question posed is why do we want change in diversity and inclusion? Why do we need it? And we need it because we want the environment and the industry in which we operate to change. And when you begin with that answer in mind, you realize that you cannot do this on an ad hoc approach, and the approach needs to be consistent. So if you want a consistent approach, one needs to understand that these legal frameworks, they are the legal instruments which you require before you can write and embed policies. The policies are meant to drive a behavioral change. That behavioral change is meant to be sustained and to create a change in our behavior. So we need to understand that the legal framework provides us with guidelines in which we can draft the policies. D&I policies have at their core to be fair, to prevent discrimination, and to promote equal opportunities. They are necessary to give effect and to encourage participation across the board amongst women, amongst newcomers. So I think the important point is to understand that we need to have a well-designed legal architecture. A legal architecture that forms the foundation for D&I policies, which encourages a culture where there is equal opportunity for all. Remembering that policies which promote fairness and encourage women participation will ultimately drive the behavioral change that we seek. And to answer your second question, in South Africa, our history, D&I policies need to address two things. we don't just need to address equal opportunity for women. I come from a country, I am part of an ethnic group which is the second minority. Indians are the second minority in South Africa. So it is a historically disadvantaged environment where the women have been oppressed or disadvantaged twice over. One, because of our gender, and two, because of our racial or ethnic minority. But South Africa has come a long way. Most of you or all of you in the room know about Nelson Mandela and the fight for democracy. The South African Constitution is amongst the best in the world. I am aware, and with respect, I understand that the Indian Constitution as well is well drafted. But in South Africa, we now have specific legislation. We have the Equal Opportunities Act, we have the Broad-Based Economic Empowerment Act, and these are all pieces of legislation which not only seek to drive transformation in our country, and that's racial transformation, but they are especially drafted to create and give women a leverage and more opportunity. I always say in a lot of my Worcester interactions that it's great to talk about equal opportunity for women. We have that. As the Secretary General said earlier on, the industry has transformed. There are women in shipping, there are women in shipping law, but we need to recognize that there must be equity. For equal opportunity to truly translate into change, there must be equity. We all have a different starting point. So equal opportunity doesn't mean a lot if it comes on its own. We must recognize and include equity in that so that we give women, and we give women previously in a male-dominated industry, the leverage to move forward. Thank you.
Thank you, Amsha. Having heard the theoretical part of it, let's just crunch some numbers with Jacqueline. She will talk to us about how numbers are going to paint a better picture, and also some of the initiatives that she believes is going to promote D&I policies in the maritime industry as global and local initiatives to progress sensible diversity and inclusion policies.
Thank you, Priya. Is this on? It's above my pay grade, the tech. You can hear me? Okay. I think what's become quite clear through listening to everybody today is that the challenges of diversity and inclusion extend throughout the shipping industry to all sectors that service it. If we take the crewing industry, for example, the global workforce of seafarers is just under 2 million people. And according to the IMO, under 2% are women seafarers. I live in London, so if we take a quick look at the UK seafarers community, unfortunately those numbers don't improve. 3% of officers are women, and 4% occupy technical roles. So if we flip this, that tells us 97% of officers are men, and 96% of technical roles are occupied by men. So when we hear these numbers, I think they paint a picture quite quickly and better than 1,000 words. The question comes, what do we do about it? There's many things we can do about it, and a wonderful example was given in the last panel of a company that quite frankly won't instruct external legal unless there is a female partner. The only thing I would add to that is make it plural, female partners. So if we look at, again, our industry on the seafaring side, something that is relevant to strengthening the legal frameworks and best practices, let's just look at where our crew are coming from. The International Chamber of Shipping lists 5 countries as the largest suppliers of officers and ratings on board ships. And these 5 are the Philippines, Russia, Indonesia, China, and India. So, presuming that there's a correlation between these countries and the origin of where the female seafarers are being sourced, it would be sensible to start looking very closely at the diversity and inclusion policies of these particular countries. It can be helpful to try and do a lot of things, but I think it can be more helpful to be very targeted with our resources and adopt, for want of a better of an expression, the approach of a sniper to look very carefully at what will be the most effective use of resources. So again, starting with these 5 countries would be a good start. The challenges extend beyond the seafaring aspect. We have 6 lawyers on stage here today. These challenges are present in the legal community. Now, one could be forgiven for thinking that lawyers and law firms would be on top of this and would perhaps be at the front of the room in terms of progress. Unfortunately, my experience of working solely in private practice for the last 20 years in 3 jurisdictions, London, New York and Sydney, I can tell you that there's some work to be done, and I expect the ladies on the panel would agree with me. In the UK, I'll give you some more numbers. The average number of female partners in private practice stands at about 20% across the shipping law firms in the London legal market. Now, what strikes us all as odd, but not surprising, is this is notwithstanding the fact that there's more girls than boys graduating from law school. Now, whilst each law firm, including my own, has written policies to address this stuff, it's not enough. The important question really is, how do we actually implement these policies to see some progress? Now, very briefly, we can look at some initiatives. On the global side, we have the IMO that's launched the Women in Maritime program. This program basically aims to facilitate women's access to maritime education, training, including women in maritime associations such as WISTA. Now, whilst it is of course positive to encourage women's education and access to women's associations, more concrete steps need to be taken to adequately address the present structural imbalances in our industry. And for me, from what I have observed and my own experiences going through the ranks as a baby lawyer to today as a partner of an international shipping law firm, we simply need a transparent means to measure our progress. Unless we're measuring our progress, and particularly the slow rate of it, it's going to be very difficult to move things forward. And an example in the UK of transparently measuring progress can be seen from a UK initiative of 2018 called Maritime UK, and it established the Women in Maritime Pledge. So basically what this is, it's an umbrella body for the maritime sector, and the program's objective is one thing and one thing only. It's to encourage companies to sign up to a diversity in maritime charter, and it attempts to do a couple of things. The first thing is to challenge companies to take concrete steps to make progress on diversity and inclusion. All well and good. We all can have our policies that set out what we're going to do and where we'd like to be. But again, the pledge also measures performance because the national performance of those companies participating are being published. So again, just to conclude, promoting diversity and inclusion is good, but measuring our progress is much better.
Thank you, Jacqueline. From the west, let's go east. And we'll hear from Catherine on the different ways in which the Hong Kong SAR region and the Singapore governments are approaching legislations and D&I policies in the workplace.
Thank you, Priya. Thank you very much. I'm following on the really
Just
interesting...
Before you start, sorry, if you could just pay attention to the timing.
I will pay attention to the timing.
Thank you.
So, I was going to use Hong Kong, which is a city-state whose history is entirely entwined in maritime and international trade, as a little case study and as an example, following on from the wise words of my dear panellists here. And I'm going to start with a statistic, if I may. According to the Hong Kong Labour Rights Monitor report in May 2023, taking data from the Hong Kong Census and Statistics Department from the census in 2021, the unadjusted gender pay gap in 2021 in Hong Kong was 21%, compared to 18% in 2018. So that's our starting point. Now, just following on from Ashma's points about the importance of the structure, architecture of discrimination legislation that needs to be in place to try and reduce these types of gaps. Getting down into the detail of this, in Hong Kong we have the sex discrimination ordinance, as well as disability discrimination laws, family status laws, and race discrimination laws. If we drill down particularly into the SDO, that law is there it states that discrimination on the basis of gender, marital status, and pregnancy are prohibited under the ordinance, and that applies both to men and women. And it covers 8 specific areas, being in respect of employment, education, provision of goods and services or facilities, disposal of management of premises, eligibility to vote, participation in clubs, activity in government, and interestingly and very specifically, participation as a barrister. Now, to try and implement this legislation, in place is an organisation called the Equal Opportunities Commission, and that was set up in 1996, and it's an independent body publicly funded by government, and it seeks to work towards the elimination of discrimination on the grounds of gender, marital status, pregnancy, disability, and family status, and so on. And it carries out investigations. It also seeks to try and reach conciliation between employers and employees. And if that can't happen, then the matter may have to go to the court, into the court system. The Equal Opportunities Commission also produces codes of practices and guidelines from employers around trying to seek to reduce discrimination in the workplace in particular. And it produces particularly codes of practice on employment, education, and race discrimination. Interestingly, if we go back to our point at the beginning about our gender pay gap issue, again, the view of the Hong Kong Labour Rights Monitor is that the SDO ordinance does not go far enough because it doesn't have sufficient teeth to implement principles in particular in relation to equal pay for work of equal value. And also, interestingly, the Equal Opportunities Commission last carried out studies in relation to equal pay for work of equal value back in 1997. It did a further consultation in 2004 and an additional task force review in 2006, but nothing further following that. So I absolutely agree that the architecture of necessary legislation to avoid discrimination in all fields, particularly in relation to gender and diversity, is essential, but I can also see that it's really essential that such legislation has teeth, and that the statutory bodies that are there to defend this legislation and ensure that it's being enforced have to have the powers and teeth to be able to do that. Having said that, and following on again a little bit about the point that Rania was making, and interestingly talking about disclosure, and in the context we were talking about carbon auditing and disclosures, again around ESG and other types of disclosure. In addition to the legislation primary legislation in Hong Kong, there's also other legislation that hopefully will have the effect of helping to reduce these discriminations and gaps. For example, the listing rules. So the Hong Kong Stock Exchange requires listed companies to produce and self-report ESG reports. And that also includes disclosure in respect of labour practices. And their guidelines, their specific guidelines in respect of employment and labour practices, recommend that the disclosure that listed companies include are their policies and compliance with laws, relevant laws and legislations that have a significant impact on the issues relating to compensation and dismissal, recruitment and promotion, working hours, equal opportunities, diversity, anti-discrimination and other benefits and welfare. So that information and the policies that companies have is a matter of public record that has to be provided in their annual disclosures in listing. The other thing that the exchange recommends is disclosing information in relation to total workforce by gender, employment type, whether full-time or part-time, age group and geographical region, as well as employee turnover rates by gender, age group and geographical region. So that's a sort of an example of a policy and a type of legislation that's not the primary legislation but secondary legislation that can hopefully bring light and assist in moving the gender diversity needle in the right way. So that's a quick trot through the Hong Kong legislation, using it as an example, as a sort of a case study.
Thank you, Catherine. But you do have some secondary legislations in place, which is indeed heartwarming to hear, because I think the need of the hour is to now move it up to primary legislations and then increase the effect of it across all aspects of workforce. I will now invite Magdalene to give her perspective on the Singapore approach to regulatory guidelines, as well as unconscious bias, cultural differences that exist in society, the very touchy issue of positive quotas, and with your special expert in mediation, how does mediation help us in this particular field? Over to you.
Thanks, Priya. And thanks, Sajjan, for inviting us to take part in this panel. When I was preparing to give my 2 cents worth, I was reminded of something that happened to me around 2015, 2016. At that time, I was newly elected as the Vista Singapore president, and my law firm, which I had started with 3 other people, 2 men, 2 women, was also in several discussions with a few international law firms about doing a formal law alliance. And these 2 instances coincided, and let me think about this issue of laws and behavior. As Vista president, we asked a very senior lawyer, and at that time she was also a parliamentarian in the Ministry of Transport in Singapore, to be our guest of honor at one of our Vista Singapore events. And she declined, her office declined rather, someone declined on her behalf. And on her behalf, they said that she felt there was really no real need for organizations like Vista, because there are sufficient laws and regulations in Singapore to ensure that equal opportunity for women and men in Singapore. Okay? Then, as my law firm, our directors were going the rounds with several international law firms, I remember being introduced to all the partners of one firm at that time, 10 of them. After they explained what they do and what we done and all the niceties, and they asked, do you have any other questions? And I said, I looked around the room and said, so, no women? And their reply, well, one reply, most of them just kept quiet, smart. One reply was, yeah, no, but we did try, but they are not, it's quite difficult. Sometimes they don't like going out in the evenings to entertain clients, right? So There is a difference, I feel, between rules and laws, guidelines, and actual behavior. In Singapore, you'd be surprised to find out that there is actually no gender-specific statutes or legislation on fair employment practices. They have adopted a tripartite approach and a sort of cooperative tripartite approach. So they have a tripartite guidelines on fair employment practices, and the three parties involve the trade unions, the Ministry of Manpower, and the Employers Association. But there is, other than provisions in the Employment Act that say that you cannot be unfairly dismissed based simply on race or gender, and provisions in the Constitution that talk about you should honor and respect everybody's race and religions, because Singapore is a multiracial, multicultural country. There is no actual statute. But recently, there has been a committee formed, and their recommendation is that there should be an act to reinforce the work of the tripartite guidelines, not to do away with the guidelines, but to supplement them and to reinforce them, because Singapore has no natural resources. The only natural resource we really have are the people. So Singapore's emphasis has always been, everybody works, everybody's productive, everybody's encouraged to get a best education possible and make a best living possible, because that, and innovate and all that, because that is our only natural resource. So in a way, that senior parliamentarian was correct. All the rules that were in place were in favor of meritocracy. Meritocracy, everybody had the equal right to education, everybody has equal right to employment, everybody gets equal pay for equal work. But the guidelines and the committee's recommendations, to me, show a slight mindset shift in Singapore. And this is just my take on it. Away from pure meritocracy towards fairness and equity. Away from ensuring everybody has the right, or protecting your right, to enabling people who may not be aware of their rights. The people who are disabled or have other incapacities, or who are older, and to try and even out the playing field, and to try to recognize systemic biases and subconscious biases. Rules per se may not always be able to address this sort of subconscious bias, as the previous panels have said. And part of the solution is not just enforcement, but enforcement through mediation, which means that to continue to build a tripartite cooperative relationship, and as and when disputes arise, to try to educate, reconcile, and resolve the problem.
Thank you, Magdalene. I think what we've heard thus far, we're quite clear that almost all jurisdictions in the world are now at least conscious that there is a need for a legal framework. There is a need for some kind of a structure to be put into place so as to give gender neutrality in the workplace. Question is that enough? And I think consensus from what we've all heard just now is that currently what's done is not enough, and there is a need to do more. There's a need for more awareness, there's a need for more discussion, and there, at least on the part of the lawyers, there is a need to bring in a bigger framework which is going to reach out to a larger audience. So having said that, I think we are out of time, and I think it's been a fruitful session. So thank you all very much, and it's been good. Thank you.